What makes a will valid in Texas? Hi, Rob Thomson here with Thomson Law Firm, and in this video I'm going to answer that question for you. What makes a will a valid will in Texas? In other words, how do you know that your will is actually valid? Well, there are a couple of requirements, and one is that the testator, and that's you if you're drawing up your own will, that the testator be of sound mind. Now, what does that mean? There are lots of different definitions of sound mind, but for legal purposes, for purposes of a last will and testament, it means that the testator understands that what they're doing is disposing of their property in their last will and testament. That's number one. Number two, it means that they understand the scope and nature of their property. They understand what they own and its value. And then the third thing is they understand to whom they're giving their property to in this document called their last will and testament. Now, if they can fulfill those three requirements, we say in legal terms they're with it. Actually, that's not really legal terms, but you knew that, right? So it means that they have capacity, okay? They have capacity to execute their will. So if that describes you, congratulations, you are of sound mind. Your mother-in-law may disagree, but that's neither here nor there. Okay, I'm making myself giggle. Okay, and then what are the other requirements of a valid will? Well, we've got to have some witnesses, right? Okay, so if it's a will that's drawn up by, for example, an attorney, then you need to have two credible witnesses. There's another word, credible. What does that mean? Well, there are lots of different meanings for credible, but in this context, it means that they're at least 14 years of age in Texas, and that they're not beneficiaries under the will, okay? So that describes credible witnesses, and there may be some other requirements as well, but we won't get into the weeds on that. And then, of course, your will should probably be notarized because the witnesses have to make an attestation. And they can't make an attestation under the law unless there's someone that they're attesting to, and that's the notary, right? Okay, so what if you don't have a notary? Well, there are plenty of notaries around. But can you handwrite your will? And will that be a valid will? Yes, you can. You can handwrite your will in Texas. You can also have an oral will. Now, with an oral will, three credible witnesses are required. I don't recommend it unless it's a measure of last resort. For example, it's a deathbed kind of thing and they just need to communicate their wishes, okay? In the vast majority of cases, the best way to get this done, of course, is to go see an attorney. But before you do that, you probably want to know, what do you need to put in your will? What else do you need to know about estate planning? Well, if you want to learn more about basics of estate planning, then you should consider getting our family estate planning guide, and you can get that for free at estateplanblueprint.com. Thanks for watching. I hope you enjoyed this video, and I'll see you in the next one.